Hello and very warm welcome to the Tax Express. Today in this important video we are going to discuss one very significant recent judgment delivered on July 18, 2023 by the Honorable Andhra Pradesh High Court in the matter of Thirumanala Konda Plywoods versus the Assistant Commissioner. This case is very important from the point of view of constitutional validity of Section 16 subsection 4. We all know that Section 16 subsection 4 prescribes the time limit for claiming ITC for any financial year up to the November of the subsequent financial year. Previously, this time limit was applicable till due date of filing GST 3B for the month of September of the subsequent financial year, that is 20th October. Recently, this has been revised till November of the subsequent financial year. In the year to which this case relates, the time limit till 20th October was applicable. In this case, the appellant filed his GST 3B return for the month of March 2020, that is pertaining to financial year 1920 on November 27, 2020, claiming ITC for the financial year 1920. The claim was rejected by the department on the ground that time limit under Section 16(4) has lapsed. Agreed by this decision of the department, the appellant filed a writ petition before the Honorable High Court. The questions of law framed before the Honorable High Court: number 1, whether Section 16(4) is violative of Articles 14, 19(1)(g) and 300(a) of the Constitution of India. Number 2, whether Section 16(2) prevails over Section 16(4), and if conditions under Section 16(2) satisfied, whether Section 16(4) time limit pales into significance. Number 3, whether filing of GST 3B return for the month of March 20 or November 20 with applicable late fees exonerate the time limit to claim ITC prescribed under Section 16(4) of the Act. Apart from challenging the constitutional validity of Section 16(4), the appellant asked the court whether Section 16(2) starting with a non-obstante clause will prevail over Section 16(4), and if yes, if conditions prescribed under Section 16(2) are satisfied, whether the provisions of Section 16(4) have no effect. We know that Section 16(2) starts with a non-obstante clause. Thus, it was a significant question of law framed by the appellant before the Honorable High Court. The appellant, through his counsel, argued before the court that claiming of ITC is his statutory right, which cannot be restricted under Section 16(4). On the other hand, the counter-argument on department's side was that in a number of judgments it has been decided that ITC is not a matter of statutory right, it is rather a concession or benefit conferred by the statute on the taxpayer. Therefore, the statute is well within its right to impose a time limit and other restrictions on availment of time limit. He further argued that to be violative of any constitutional provision, it must be shown that the provision in question is arbitrary in nature. On the issue whether Section non-obstante clause in Section 16(2) prevails over Section 16(4), the court observed, non-obstante clause is a legislative device usually employed in a statute to give overriding effect to certain provisions over some other contradictory provisions in the same or other statute. The court shall try to find out the extent to which the legislature had intended to give the overriding effect to the enacting part of the provision, succeeding to the non-obstante clause over rest of the provisions. The court dealt with his issue in detail and referred to various decided case laws. The court finally held that non-obstante clause in Section 16(2) restricts the availability of ITC under Section 16(1) only, subject to conditions prescribed in subsection 2. It does not therefore have the effect of overriding the other provisions of the section as a whole. The court held Section 16(4) is not violative of Articles 14, 19(1)(g) and 300(a), so the constitutional validity of this section held to be intact. Number 2, Section 16(2), which start with non-obstante clause, and Section 16(4) are independent sections which operate independently, and therefore Section 16(2) does not prevail over Section 16(4). Number 3, payment of late fees does not exonerate the time limit prescribed under Section 16(4). With this judgment, the Honorable High Court also made it clear that ITC is in the nature of concession or benefit conferred upon the taxpayer by legislature and cannot be claimed as a statutory right. The legislature is justified in prescribing restrictions and conditions subject to which ITC can be claimed, whether it is prescribed under Section 16(2) or under Section 16(4). It is a significant judgment on Section 16(4), and it remains to be seen how does it affect the pending writ petitions on constitutional validity of Section 16(4) in various high courts of other states. This judgment holds good for the state of Andhra Pradesh, and for other states it will have a persuasive value, and department can use this judgment in those cases in their favor. This judgment drives home the point that taxpayers are required to abide by the conditions and restrictions subject to which the concessional benefit of ITC has been granted to them by the statute, and that none of these restrictions can be claimed to be unconstitutional merely because of their restrictive nature, unless it be shown that any of those restrictions were arbitrary and violative of taxpayers' constitutional rights. So this is the latest update from GST. Hope you like it. Please subscribe to the channel and get all their tax updates regularly on time and hit the bell icon. Thank you very much.